Let us get started so that you can have a full hour with our guest today. I am Ted Merman, the interim director of the Center for Consumer Law and Economic Justice. There are many ways to introduce our guest today. I'm going to take a personal path that will illuminate some of his achievements, but very few, because that's not what he is here for or is ever about. So I first heard of David Vladeck 20-something years ago, just after I left this venerable institution. I was working on the East Coast, and my not yet wife, now known as Professor Polsky, was working at a place called Public Citizen. And she had this mentor there. She had left here. She'd gone to work there. She had her first case as a lawyer. It was in a little court in Washington, D.C. called the Supreme Court. And she was second chairing with this guy that she just could not praise highly enough. And that was the first that I had heard of David Vladeck. We fast forward another 10 years or so, I accidentally find myself in the field of consumer protection law. I'm working at the California Attorney General's office in the consumer law section. And there's an agency that a federal agency, this is during the George W. Bush administration, was quite timid in my extremely narrow experience and limited experience at the time. The Federal Trade Commission, it seemed, if not irrelevant, our relationship with them was, hey, let's go after this company. Then we'd hear from them, we're thinking of going after them, please hold off. And okay, we'll hold off a little. And then they give them a little slap on the wrist. And I would say, that is why you asked us to back off? And I thought, all right, well, that's the way that these things work. 2009 happens. And suddenly, we're hearing very different things from the Federal Trade Commission. They start, as part of settlements of cases, they start banning people from who have been ripping people off. They start banning them from that industry for life. They start getting very powerful injunctive relief of that nature. They start cleaning up the landscape. They move to the fore. And then I was working with the Consumer Justice Clinic at EBCLC, and the word comes down. The FTC calls us. They say, can you help us? We have word from headquarters that we're supposed to be meeting with legal aid in order to find out what's happening on the ground. So the Federal Trade Commission wants to find out what's happening inside a legal aid office, what's happening to the clients in Oakland and in Berkeley and in Richmond. And I thought, what is going on here? Well, what was going on there was that the Bureau of Consumer Protection had been taken over by the same character whom I had heard so much about 10 years earlier. He was a legend at the Public Citizen Litigation Group, a legend again at the Federal Trade Commission. His interests span what we call public rights, from environment to privacy and all sorts of consumer protection, and on and on. But he has been a tremendous mentor to many of us. And I will say, one seriously benighted person said to me a few months ago, "Oh, you're Ted Merman. I heard you were the David Vladeck of the West." And I said, "You are so wrong, but I have never received such a high compliment." Ladies and gentlemen, David Vladeck.
That was so over the top. I think my father would have enjoyed it and my mother might have believed it. But let's talk about consumer protection. And it's great to be here. This is sort of like coming home because in addition to having a chance to work with Claudia, and we won that case largely because of Claudia's advocacy. This was a hard case. The question was whether prison guards who worked for a private prison that had state prisoners were entitled to qualified immunity under Section 1985. And for those of you who do civil rights laws, know that if you get qualified immunity, the plaintiff almost always loses. And we argued that for a variety of reasons, most of which Claudia came up with, qualified immunity was inappropriate. It should be a state law question. And the court shockingly agreed with us 5-4. So chalk one up for Claudia. But it's not just Claudia who's here. I mean, one of my great pleasures was working with Ann Bloom when I was at Public Citizen. Lucinda Sykes and I litigated cases together, and there are many other folks here that I've worked with and have just enormous respect for. And, you know, this is one of the few law schools where you can get a bunch of students who want to talk about consumer protection and privacy. So I'm really delighted to be here, and I'm really feeling honored. So let's talk a little about why consumer protection these days is in dire trouble. First of all, you have a serial fraudster in the White House. We now have a guy a guy who worked for a company under an FTC order as Attorney General. The case underlying the controversy over Whitaker is a bad case. I mean, this was an outright fraud. It scammed something like 25 million people, $25 million out of a bunch of people. And Whitaker seems to have been at least up to his knees, if not his neck, in the scam. And it's going to be interesting to see whether there are other repercussions, because one of the things that's not visible to the public but is well known within the law enforcement community, in cases like this, there are often parallel investigations. The FTC tries to go in quickly, stop the fraud, get whatever money there is to be had so we can do consumer redress to consumers. And the FTC can act very swiftly. The Department of Justice cannot. Putting together a criminal case is time-consuming. You can't just run into court and indict somebody. So it's going to be interesting to see whether there are criminal indictments that flow from this. But so we have a fraudster who is now the Attorney General. We have people like Betsy DeVos, who is a huge fan and owner of private colleges. So there's been a hostile takeover of the administration. You've got real problems in the field of debt. I'm going to come back to debt and what debt is doing to our country. You've got massive identity theft, which is a predictable degree of an internet economy where data security is not valued, and there's really no cost, no serious cost to companies that experience breach. You've got, now the sort of the intersection of privacy and consumer protection is complete. Virtually every scam we worked with when I was at the FTC was an internet-based scam, and for good reason. And privacy these days, the lack of privacy is feeding all sorts of scams. And so let me start with just debt. I mean, how many of you are going to leave law school in debt? Any of you not? You are the lucky ones. Well, debt is a real problem in the United States, simply apart from the rising amount of debt. But if you look at what the CFPB has done and the Department of Education has done in terms of being able to raise defenses to debt that was fraudulently incurred, that's become way more difficult. So one of the things that I've worked on is shutting down these for-profit schools that advertise based on claims of subsequent employment. The come on is, if you want a good job, if you're underemployed or unemployed, sign up with us. Here are our statistics about employment. Well, most of those statistics are not accurate. Many of them are completely made up. And yet, the borrower rule has now been changed to make it much more difficult to raise an affirmative defense that you were one of the tens or hundreds of thousands of people cheated by these scams. 1 out of every 7 Americans annually is subject to some sort of fraudulent conduct. 1 out of 7. Now, the FTC has been doing studies of fraud for decades. And one of the things that's really unfortunate is that number doesn't change very much. So another problem is that this is a stubborn issue that law enforcement has never really been able to make a real dent in. Why is that? Well, the FTC is a relatively small agency. It has about 1,200 staff, which is about 2/3 the number of staff members it had back in the 1980s. And it has a mission that spans not just consumer protection, but also antitrust. So the agency is responsible for sort of being the fraud fighters for the United States government, with about 430 people working on consumer protection, and that encompasses false advertising, financial practices, financial services, all sorts of other things other than just fraud fighting. So you look to the states. Well, you live in California. There's actually a very aggressive, well-financed state AG. But on the main, state attorneys general are not really well positioned to do consumer protection work. Most of the funding for consumer protection work in most states comes from civil penalties the attorney general can get in fraud cases. And oftentimes, you shut down a fraud, there's no money. So there is not a sort of strong blue line of state law enforcers. It's very difficult for private lawyers to make a big dent in scams. Yes, they may be able to get money back for the consumer they're representing, but we as a nation seem to be willing to tolerate fairly high degrees of fraud without really ever coming to grips with the fact that it's an enormous drain on the economy and it is ruinous for people who are caught up in these scams. Let's talk a little about privacy and why privacy and consumer protection, fraud issues, so greatly intersect. How many of you knew what Axiom is? Okay, I think there are 3 hands up, 4 hands up. How many of you know what data brokers are? Okay, so data brokers, so in the old days, people were worried about the NSA. You remember the NSA revelations about how much data the NSA was scooping up on your email traffic and on the phone calls you made? Well, trust me on this. Axiom knows far more about you than the NSA will ever know about you. We did a study of data brokers, which is now out of date. We finished the research part of this in 2012. But at the time, Axiom, which is the world's largest data broker, had about 5,000 data points on every adult in the United States. That number has increased probably geometrically, not arithmetically. So, and why should that matter? Okay, so how many of you are on Facebook? Okay, so Facebook sells advertising, right? The advertising they sell is based on what they know about you. They know a lot about you because you post things, but that's not the only way they know about you. Facebook routinely, I think they claim now that they've stopped this practice, but Facebook would go to data brokers to buy data to round out their profiles on people. Why would they do that? Because they can charge more in advertising prices. So one of the most successful ad programs Facebook runs is what's called a mirror program. Now, we've just finished an election cycle. So suppose you were a candidate and you all, let's hope you all run for office at some point. We need better candidates, right? And who could be better than you guys? So you run for office and you have 1,000 supporters who are dedicated to you. They give you money, they knock on doors, they man phone banks for you. You want to find thousands of people just like the people who are your strongest supporters. Facebook can do that. So you will pay Facebook to send messages to people who mirror on many, many different axes the people that you want, the people you know are solidly behind you. This was one of the fundamental things that the Trump campaign did so well back in that dark day when we lost an election. Okay. So why should you worry about that? Well, it's not just that they're acquiring data, but there are lots of people who work for Facebook who are trying to figure out not just your preferences, but your preferences that can be turned into selling options. So how many of you guys like donuts? I'm shocked. There are people in this room who don't like donuts. I don't know what's happened to law school these days. That would be my only admission question. Anyone who said no, they can go to Harvard. I don't care. So suppose you have a cell phone. Does anyone here not have a cell phone? All right, so suppose you have a cell phone. And as you walk by a donut shop, all of a sudden your phone buzzes and there's a coupon for a donut. Instead of paying $1 for a donut, you can pay 30 cents for this donut, right? This is the kind of advertising that is now starting to be used. It's geolocation advertising based on preferences. And if your credit card information shows that 3 times a week at 9 o'clock you go to Joe's Donut Shop and buy a donut, well, Facebook may find out, or advertisers may find out, and as you go past Joe's, you may get that on a different day of the week. You may get that buzz, and who can resist the donut, particularly a cheap donut? So you can't, right? So the question is, what does this have to do with scam artists? Well, Facebook doesn't necessarily know who's a scam artist or not. There is no, as you're filling out your form for advertising, as you know this because, the Russian intelligence people were able to get all sorts of advertising on Facebook. And it's very difficult and probably impracticable for Facebook to actually verify the bona fides of everyone who wants to take out ads. Well, increasingly, there are scams that are advertising on Facebook. They look to Facebook like perfectly legitimate advertisers, but they're not really selling a product, like the scam Mr. Whitaker was involved in. This was a scam that promised people who had inventions that they would help them obtain a patent and market their invention. And these kinds of scams are not uncommon. This is not the first time we've seen these kinds of scams. And these are attractive scams because you're actually trying to target people who have some money. So when I got to the FTC at the beginning of 2009, a lot of the scams were targeted really at taking the last dollar out of people's wallet. They were targeting people who were just been laid off, they needed jobs, that sort of thing. But a patent scam, you're talking about people who have some means, which is why some of the people scammed in the Whitaker scam were scammed out of thousands and thousands of dollars. So if you're looking for people who are inventors, who care about inventions, who check the patent office all the time, there are probably all sorts of markers that might lead you to believe that someone was trying to invent something, trying to market a new invention, trying to patent something that they wanted to then take to market. The ability of companies like Facebook, and Facebook is just, it's easy to kick because it's down these days, but their business is acquiring very robust sets of data so they can exploit that data to figure out what your preferences are. And increasingly, it seems to me we're seeing scams based on ads based on preference. And I'll bet, and we'll have to see what the Department of Justice finds, I wouldn't be surprised if Facebook were using its database benignly, because I don't think they had any idea that this was a scam, to try to attract people to use this service, which was not really a service. So one concern about privacy is, there is no federal law, and at the moment there really is no state law either, that restricts the movement of data. So Axiom buys data from all sorts of companies. Axiom sells data to all sorts of companies. And the aggregation of this data, so my colleague Paul Ohm is now a law professor at Georgetown. But he was brought into the FTC in 2010 because he's one of these rare lawyers who also is a nerd. And I say this incredibly affectionately. But he's got like 13 computers at home. He builds robots. He now teaches courses at Georgetown, programming for lawyers. So we offer courses in introductory Python and advanced Python. So he's a nerd. But he wrote an article about 10 years ago where he forecast something called the database of ruin, which is the pooling of data to the extent that everyone has at least one piece of information in this database that you'd be mortified if it was ever disclosed. And as data sharing becomes more ubiquitous, and as our legal institutions have failed to sort of try to place meaningful restraints on data sharing, you have data brokers and you have data holders like Facebook or Google or Axiom that may well now be something equivalent to a database of ruin. And so, not only does this sort of test what privacy really means, because a lot of your data is shared without you knowing, and certainly without anything approaching meaningful consent, but this data can be used for all sorts of utterly benign purposes. If you like leather jackets, you may get a lot of ads for leather jackets, or if you're like me, you may get a lot of ads for donuts. And bring that on. But your preferences also can be used in ways that are not necessarily beneficial to you. And increasingly, companies that are data holders are hiring platoons of psychologists and other people who can fine-tune preferences, who can try to assess what is your, they would say, what is it that you most crave, but our weaknesses. And so I think that's a problem in its own right, but I think it's also a problem in terms of the use of this kind of data for really nefarious purposes like scams and identity theft and things like that. So what else do I want to talk about? Let's see. Well, first of all, are there questions from you? What do you guys want to talk about? I can keep on going, but what else do you guys want to talk about? All right. Oh, yes.
I think these companies have a First Amendment right to buy data. I was just curious.
Well, so the closest case is Swirl. There's a case called Swirl versus IMS. IMS is a huge data broker. IMS probably holds a huge amount of information about the health status of pretty much everyone in this room. It buys up prescription data. It buys up whatever data they can get from public records. And so the case before the Supreme Court in Swirl actually was not a question about buying data. It was about buying data for a specific use. So the state of Vermont, and let me start out by saying two things. I thought this was a bad case for the state of Vermont, and I actually spent time on the phone with Mr. Swirl, the Attorney General of Vermont, urging him not to file a cert petition in this case. So I think this was not a good case to take to the court. Also, because the cert was granted on an expedited basis, it was the last case argued, okay, in that term. It was the last case argued in April. So some poet, what was it? One poet said April is the cruelest month. Which poet? Pardon me? Who said April is the cruelest? No. T.S. Eliot, thank you. My scholar here. So if you're a Supreme Court advocate, April is the cruelest month. You always want to avoid being at the tail end of a term. Why? The case was argued in late April. The court goes home no later than the 4th of July, right? They're not ever going to be there, and they really want to get out of there in the third week in June. So I'm no mathematician, but that doesn't give you a whole lot of time for a consensus position to develop, particularly in a complicated case. And so the opinion by Justice Kennedy in Swirl is an utter mess. But it does stand for a related proposition, which is the state cannot engage in viewpoint discrimination. And so what happened in Swirl was that there are people called detail men who work for pharmaceutical companies. These are people who want doctors to prescribe their drug over another. They're pushing brand name drugs, not generics. Generic companies don't have detail men. And they go into doctors' offices and they tell them why they should be prescribing one drug rather than another, and why they should stick to the prescription drug rather than the generic drug, even though the prescription drug is invariably more expensive. So what Vermont wanted to do was to sort of basically drain the information that detail men would have about the doctor's prescribing habits when they visited a doctor, so that they would not know that the doctor prescribed their rival's drug. Why? Because what the state wanted to do, and the state is the payor here, the state wanted to make sure that as many people as possible were prescribed the generic version of the drug. So what they said was, we're not going to let this information go to IMS because they're going to use it to basically speak to doctors about their prescribing habits in a way that would persuade them to prescribe the prescription drug. And the Supreme Court, in an opinion that doesn't really make a whole lot of sense to me, said that's classic viewpoint discrimination, because if there were detail men on the other side, they could use this information to argue in favor of a generic side. And so the state cannot engage in viewpoint discrimination. The state also tried to make an argument based on privacy, but that's not the argument they made in the Second Circuit. The Second Circuit, this case, Vermont, for those of you who've never been east of the Mississippi, Vermont is actually part of the Second Circuit. It's not just New York. So I know it looks that way on a map because Vermont's really small. So that was the problem in Swirl. But there was a strong dissent because the serious question that's raised there is, to what extent does the First Amendment disable the state from trying to achieve important policy goals? So you go back to a case called Sauter versus Office of Disciplinary Counsel. It's a case that's old. It's like in the 1970s, maybe early 80s. Sauter was a lawyer in Ohio who was trying to get plaintiffs to participate in cases involving a product, an interuterine device called the Dalkin Shield. It was made by one company, A.H. Robbins. And there were serious problems with this medical device. Women had all sorts of very serious issues. Some died, others became sterile, others lost children. So what he was doing is trying to get women who had been injured by the Dalkin Shield to come be represented by him. And so the major question in the case, the Ohio Office of Disciplinary Counsel, the bar in Ohio, disciplined him because he used a drawing of the device in his newspaper ads. And he did so because he only wanted to attract women who used the Dalkin Shield, which was vulnerable, and it was the only way to differentiate the different devices. So the Ohio bar sanctioned him very severely. There was a cert petition that went up to the Supreme Court, and the court ruled, and this is the First Amendment argument, the court ruled that he had every right to use this illustration. But there was a second argument. The Ohio bar also said that because he was charging a contingency fee, and under Ohio law, the client had to remain liable for contingency fees, even if he never sought to collect them. And even if he told his clients he would never collect them, he still had to disclose that under Ohio law, if the plaintiff didn't prevail, the plaintiff would be liable for costs. And the Supreme Court upheld the sanction against Mr. Sauter for failing to make that disclosure, even though he argued that this would be essentially untrue and would be counterproductive. And there were other arguments. So what's been known as the Sauter Test is now the test used, and this is an issue that's being fought out in every court of appeal in the country. So the Sauter Test basically says that the state can impose restrictions or even compel speech, provided that there is a reasonably strong public interest in doing so. And the compelled commercial speech cases, the Ninth Circuit has had several of them involving cell phones and sugary drinks. Those are the two major ones. Yeah, whatever you're drinking today. And so the question is, can the state say, for example, that the manufacturer of a cell phone has to disclose that there's a chance, not a huge chance, but there's a chance you may get brain cancer, or that sugary drinks lead to obesity? Diabetes and tooth decay. Yes, it's always tooth decay. That almost killed off the FTC. Yes. So you're asking what's really a difficult and highly topical question, because the Supreme Court, since Sauter, has never revisited this, and you have all sorts of disclosure regimes, like sort of like Swirl, but like the one in, I think it's San Francisco that requires the cell phone, or Berkeley. Berkeley. And Berkeley is the cell phone, and the sugar drinks are San Francisco. So I can drink sugar drink here, but I can't use my cell phone.
You can drink it in San Francisco, you just have to drink it with a dose of warning.
Okay. So that is the big issue. And every circuit is confronting to what extent does the government need to prove a strong interest. And, so the questions generally revolve around, is the compelled speech important? And second, is it accurate? And third is, and this is the hard one, suppose it's controversial. Suppose it forces a product to engage in something that one of their lawyers might call self-defamation. Like the producers of Coke having to put on their can, drinking this Coke may contribute to the risk of diabetes. And those are the questions that the court's sorting out. And the folks on the consumer protection lawyers very much want to see government have some leeway in imposing these kinds of mandatory disclosures. The industry, not so happy with this. They don't want government to tell them what they have to say. They assert not just protection under Sauter, but they make stronger First Amendment arguments. And this is the hottest issue in the First Amendment right now. This is it. And we'll see how it comes out. Someone had, yeah. Okay, so there are two. I'm not sure I heard the first question, which is data as
independent market in itself. Could it be defined as an independent market in the competition?
So that's a question the FTC ducked in when Google acquired AdClicks and AdWorks. And I think here's the problem from a competition standpoint, which is. And the accountants haven't figured this out either. So it's not just the lawyers who are obtuse. The accountants are every bit as obtuse. How do you value the data Facebook has? How do you value it? For accounting purposes, people just throw up their heads. And how do you value your data? I mean, so one question is the valuation issues haven't really been resolved. One could argue you just look at the market cap of Facebook, and that's its value. Though, as anyone who follows Facebook knows, its value has tanked in the last couple of months. And accountants don't like that because they want to be able to put a firmer value on things. So that's a problem. And in terms of antitrust, I mean, the difficult question is what constitutes consumer welfare, right? And this is the issue that is, the FTC is really trying to work through right now. They've been holding hearings on this. There was a first set of hearings a month ago at the FTC, at Georgetown, because we're right there. But it depends on whether consumer welfare is viewed through the lens of price, which is the traditional antitrust metric, or is it viewed through a broader lens? And if you look at competition issues through price, the pricing mechanisms of antitrust law assume that if you're using Google for free, it's free. Even though we all know it's not really free, you are compensating Google by having access to data. So you've asked the vexing question for antitrust. There's always been concern about the platforms. Tim Wu, who actually worked with us at the FTC for a while, wrote a very powerful op-ed, I think it was in the New York Times just in the last couple of days, basically arguing against bigness. He really thinks that Google ought to be broken up into its constituent parts. So you have search, you have YouTube, you have Alphabet, you have Waymo. And even then, he's worried about the bigness, because if you break up Google into its constituent parts, it will still be the biggest part in each of the fields that it plays. So this, again, you're asking a question that is really the key question of the day. My sense is that unless Congress gives the regulators more room to operate, they're going to have to apply conventional antitrust theory, which means that monopolies are not bad as long as people are not paying a premium price, and they don't acquire the monopoly through bad conduct. And so it's going to, I think, and Tim is basically arguing our antitrust laws, the Sherman Act, is actually even older than I am. It dates back to the early 1900s. We haven't really revised our antitrust laws in more than a century. And that's bad because the economy has changed, markedly since then. Yeah.
Picking up from the antitrust laws, the Sherman Act seems to be constructed pretty neutrally in economic terms, but the Clayton Act has a clear mandate to clamp down on unfair practices. So why does the FTC not enforce against data holders like Amazon, for instance, on the ground that their practices are unfair?
So what practice is unfair?
I'm thinking like when Amazon hosts distributed on their platform and then use their data to go and manufacture similar products. That seems like something that's clearly unfair.
Well, so you get back to the ultimate conundrum that the FTC has had and the courts have had, because Congress deliberately chose the word unfair, but it meant consumer. If you go back and look at the legislative history of the FTC Act, unfairness was defined by serious consumer harm. That is the yardstick by which unfairness is measured. And so if there is a practice that causes consumer measurable harm, maybe there's an unfairness case. But that gets back to some of the fundamental questions about what is harm and what is consumer welfare. So I'm not sure I can answer your question other than to say Congress has, of course, cabined what the FTC defines as unfair under Section 5. And Section 5 drew heavily on the Clayton Act. So I don't, I'm not, so for example, Congress says that for the FTC to make an unfairness case, we have to show actual or imminent harm to consumers, harm that's not reasonably avoidable, and there's essentially a cost-benefit test at the end of this, which is that the injury to the public, to the consumer, must outweigh the benefits that the conduct provides. So it's not a free-floating unfairness test. It's pretty heavily anchored in both precedent and in congressional intent.
Well, what about your view on unfairness to competitors? Do you think that's excluded? Should be excluded?
You guys have asked every single hard question. If the answer to me is should it be excluded, no. And when I was at the FTC, we brought some unfairness cases where competitors were harmed. We brought a case against Intel because AMD was harmed in the semiconductor market. Competitor harm is the touchstone of the antitrust regime in the EU. But it has never been the principal focus of American antitrust law. And if you read Tim's point, he would like to see your approach adopted here. And again, I think that the regulators would like the freedom to do this, but I think they need some sort of signal from Congress. You had your hand up?
So if I go to the supermarket one month ago and I get a shiny red apple for $1, and then I go today and I go and get an apple that's full of mold, and has worms in it for $1, maybe the price term hasn't changed, but the quality has.
Right.
Antitrust law can't take that into account. What's it even good for? And likewise.
Well, so the question is, what are you being told about that apple? If you're being told that apple is the same quality of apple, they're grade A apples, right? But the second one you bought is a grade C apple, then that's a deception case.
Yeah,
and the question, I'm sorry, go ahead.
From a consumer protection standpoint, but let's say, before a merger, I can go and access YouTube and watch my YouTube videos with giving no data.
Right.
After the merger, I have to go and give my geolocation data, all of my preferences, create an account that tracks me everywhere else that I go on the web.
Right.
That's a difference in quality, even though the price term hasn't changed.
Right.
Consumer welfare harm.
Right, so the antitrust laws would say in a competitive market, if they kept on giving you wormy apples, you'd go somewhere else. Right? So that's the first tenet of the antitrust laws. And it's not worried about you getting a wormy apple if there's a competitive market. And so let me just finish. So on the other hand, if you are, and if you are so you're not going to remember any of this, but in the old days when I was a kid, there was essentially a monopolist in terms of supermarkets. It was A&P, the Atlantic and Pacific supermarket, and everyone went to A&P. And ultimately, what you have just described happened, and the Department of Justice brought a monopolization case against A&P because they had basically, kept prices the same, but the quality had degraded. And because they were freezing, and because of their monopoly power, they were freezing out competitors who could offer you a good apple for $1. So, now that was a very controversial move by the Justice Department. But that's sort of, I think that's your case.
So why can't the FTC take that into account when it comes to platforms, online platforms that offer, zero price services, or in mergers between companies that offer zero price services? There is an accounting measure of this value. It's the average revenue per user that they get by selling their information to data brokers.
Right, but then
that's like $26 a year.
Right, but that price is right. But if you talk to an accountant, they wouldn't believe that price. But that's a separate question. So to answer your question, at least I think I'm answering your question, that's exactly the question the FTC is discussing now. Because, again, by many markers, the fact that the services have changed and, in your view, degraded over the years doesn't really matter because you're not paying anything for it. That's the question. Your Apple example, you're paying $1, right? But if you decide you don't like YouTube's terms of services anymore, it's not going to cost you a penny to just not use it. That's the antitrust conundrum. What is the consumer injury? That's the problem. And I'm not suggesting you don't have a point. That's exactly the point the FTC is considering. But historically, people would say that the long-established legal doctrine of tough noogies would control, and if you don't like a free service, tough noogies. I know that's not a very satisfying answer, but that is, look it up. There's a doctrine there. Yes?
But privacy typically is like injury, like defamation, where it's about your self-image. But all the companies are now moving towards, we're going to anonymize everything. No one has a self-image problem, and then that way they think they're going to avoid liability. So in the American system, where everything is about imposing liability after the fact, towards less regulation, does it make sense to try to impose liability on data companies? One, distributing their data results in a scam. And you lose money, but what's the injury?
Well, there are statutes. So there are statutes. Well, then you get to torts, foreseeability, and I don't think about torts. But reasonableness and foreseeability, isn't that all there is to torts? And if that's the case, then you'd have to figure out whether this was reasonably foreseeable. But to get back to your broader question. The problem for the legal problem about this data is not that it's foreseeable that it would be used in the tort sense, right? I don't think if the victims, assume two things. Assume the victims of this patent scam. Assume that they contacted this scam because of a Facebook ad, right? I don't know whether any theories of reasonable, they have 1 million advertisers, and foreseeability would apply any more than if the New York Times issued an ad. So let me tell you about a real case. It's the Dutchman Industries. There's a guy who claimed to be an MIT graduate who advertised in things like Popular Mechanics, an ad that can convert any car into a hybrid. You can pay $40 and you're going to get a kit that's going to convert your car into a hybrid. The kit, which we ordered, many kits actually. We were one of his customers. Were just a series of magnets that you put under the underbody of your car. And you know what? We tested it, and it had nothing to do with fuel economy or anything else. It was a bunch of magnets. Now, the question is, take Popular Mechanics or one of the other science-based magazines. Should they be liable if somebody bought this because they read it in Popular Mechanics and thought it was good? Now, if you took torts, your answer may be yes, because they've republished this. But I think as a practical matter, I wouldn't have brought that case when I was at the FTC. I didn't bring that case when I was at the FTC. We sued the Dutchman. He's under order. He's not going to do this again. If somebody else tells you that they can give you a little device that's going to turn your car into a hybrid, don't buy it. Yeah, but that's, that's the way the legal system works. Yeah.
On a slightly different topic, it seems like even beyond tech, my sense of antitrust enforcement for a long time is getting less aggressive.
Which enforcement, I'm sorry?
Antitrust enforcement. And I'm thinking of things like the airline industry, right? We've had all these mergers, and now there's higher fees, and the airlines are making increasingly a lot of money on fees. And that seems to be happening across the economy, not just in tech. Is there any movement towards shifting back the other way and becoming more aggressive?
Well, it's hard to, the antitrust problem is it's hard to unscramble the eggs once they're an omelet, right? Or that may be a bad metaphor. But I think there's anyone who flies, as I did this morning, is appalled at airline service. Now, for those of you who didn't exist prior to deregulation, airline service wasn't great either. We all have this nostalgic view of low-cost airlines, including Trump Airways, all of which went bankrupt pretty regularly. This deregulation, which is what prompted this, unleashed all sorts of consolidations. And, is airline service dreadful? Yes. And is the way our market works stifling innovation? Probably. I mean, Americans pay more for air service than Europeans do. I think everybody's service sucks, so I'm not sure they're service comparisons. But yes, I think the antitrust folks would say deregulation has had some serious costs. And you live at least in a city that's well served by airlines. But my wife's family, some of them from western Wisconsin, and flying to Madison, Wisconsin, a state capital, is a nightmare. Delta from D.C. has one nonstop service a day. You either fly through O'Hare, Detroit. I guess that's it. So I don't disagree with you. And particularly in a field like aviation, where the barriers to entry are extraordinarily steep. So I was unhappy to see the Department of Justice approve these mergers. And I don't think they were the right policy. But I do think I'm sorry. Go ahead.
Do you think the trend is shifting at all towards not approving future mergers like that, or is it just too late and now we're stuck with it and it is what it is?
So I think that the Department of Justice, the guy heading the antitrust division, is not going to be an aggressive antitrust enforcer. And they have airlines. The two agencies, the FTC and the Department of Justice, have carved up the economy in all sorts of weird ways. So airlines, I'm happy to say that they've been poorly done because that's all the Department of Justice. And we don't get along. I think we'll see a year from now. Maybe you'll ask me back and we can do a critique of the FTC. But I'm sort of mystified as to how the commissioners were appointed to the FTC, because most of them are pretty enforcement minded and I think are going to be much more aggressive than you would expect from this administration. I think there will be I think they're going to take a hard look at this part of the world. Not you guys, but everything that goes around you. I mean, I think they're going to take another hard look at Silicon Valley. So I do think, everybody is very concerned about the power the platforms have. So I wouldn't be surprised, but we'll know in a year or so. All the way in the back.
So we haven't touched on this yet, but I was just wondering if you could speak to the importance of administrative rulemaking in governing your work, and how you think that might, the model that's on the hour, might affect the FTC's ability to keep up with changing technology and other privacy concerns.
So the FTC is one of the few agencies that lacks general rulemaking authority under Section 553 of the Administrative Procedure Act. And for those of you who've taken administrative law, you know that the common way of developing rules is through what's called notice and comment rulemaking, which is arduous but doable. And the FTC was delegated authority by Congress to do some rulemakings under the APA. For example, and many of you are probably too young to remember this, but at the outset of the economic downturn in 2007, 2008, you couldn't drive in a car with the radio on or watch TV without the following ad. If you owe more than $5,000 in credit card debt, call us. We'll help you get things right. These were called debt settlement agencies. They were all over the country, and most of them were scams. They didn't figure out whether you could actually pay the debt back, but they charged you enormous fees to manage your debt, and so your trip from simply being a debtor to bankruptcy court was shortened quite quickly because they drained whatever you had, then you'd be stuck declaring bankruptcy. So we had rulemaking authority. So at the beginning of this wave, the only way we could go after these companies, which we did, is carpet bomb them. We started bringing lots of enforcement cases against the biggest debt settlement companies in the United States, but we simultaneously embarked on a rulemaking because the FTC does not have fining authority for initial violations, except in certain statutory areas. So the only way we can really, get somebody for the first bite is if there's a rule. So we promulgated a rule regulating debt settlement companies in 9 months, which is incredibly quickly for a government to go through the notice and comment process. But we were intent on giving ourselves the tool of civil penalties to go after this scourge. And it was incredible. I mean, once we had a rule, state AGs were doing this because there were civil penalties involved. And so by the end of 2011 or 2012, we had taken virtually all of the players off the table. So that is the value of rulemaking for consumer protection enforcement. But we don't have that authority generally. And so the FTC has, on a bipartisan basis for the last 20 years, asked Congress to give the agency two things: general APA rulemaking and original fining authority. Now, with respect to your question about technology, I think there's a lot the agency could and would do if it had APA rulemaking. I mean, data breach, there are things that we could do about setting industry standards, performance standards, because these days, if you look at the literature, and the RAND Corporation has published a number of really great studies on this, it's not necessarily economically rational for a box store to really care about its defenses. It's more expensive. I mean, and so the guy's name is Sasha Romanowski. He's a brilliant guy. He's published a bunch of these studies. And what the FTC can do is get them under order. So if they do it again, there could be civil penalties. But the first breach is free. And that's why identity theft is such a large problem here. It is the predictable debris of an industry that doesn't really take security seriously enough. So I assume your presence means that we're done.
No, we're going to give the last question to
It's been great to hear all the consumer privacy reasons, but I know that the American Constitution Society, is that right, is one of the co-sponsors, and I wanted to let them get a question in about the Supreme Court litigation. You were our mentor, Deepak Gupta, was here a few weeks ago.
Right.
Some tips for future Supreme Court litigators in the room.
Be like Deepak. I hope you all went to see Deepak. Deepak was a former student. He was a public citizen, and he is. And for those of you who didn't see this, he got just an extraordinary honor 2 weeks ago. The Supreme Court, when the government refuses to defend a position it took, or like the constitutionality of statute, the court itself intercedes to appoint an advocate to defend that position. And virtually every lawyer appointed to argue in the Supreme Court by the court is a former law clerk. Deepak, who is not a former law clerk, was just asked by the Supreme Court to argue a case where there was no one else to basically defend a position, which is just an incredible. I mean, Deepak is like, 16 or something? It's an incredible honor for any Supreme Court advocate. But for someone who is still a relative newcomer to Supreme Court practice, this is really an incredible tribute to Deepak. So I'm happy to answer a question. Was that a question?
Well, I was really just saying any tips for future Supreme Court.
Oh, yeah.
Because you've mentored a lot of them.
Oh, so I think, if you want to argue in the Supreme Court, you got to be a litigator. Many of you I know are going to head to big firms because you have to pay off those debts Betsy DeVos is not going to let you get out of. It's her fault, I know. But you go to somewhere where you're going to get experience. Go to an agency. Go to a state AG's office. Go to a public interest group. Government lawyers get experience much more quickly than at a big firm. And big firm training is fine. I don't urge people not to do it. But if you really want to end up in a practice where you are a Supreme Court advocate or you regularly argue before courts of appeals, you need to be a high volume practice. One of my fellows just had her first argument in the D.C. Circuit yesterday. And the people who mooted her were people who worked in the government. So Georgetown has been fortunate because some of the people who've left the Trump administration are now at Georgetown. So one of the people who mooted her is a guy named Doug Letter, who had been in civil appellate Justice Department for 35 years. He just got the job he really wanted. He was the head of the civil appellate unit at the Justice Department, and after 9 months of the Trump administration, he just quit. But that was good for us because he's argued, he's lost count. But the last time he counted, which was years ago, he had argued more than 200 cases in the courts of appeals. 200 cases. And he'd argued in several cases as a Justice Department lawyer in the Supreme Court. And having argued many cases against him, he's a brilliant advocate, but he didn't start out that way. We came up together, in our first couple of arguments, we both sucked. Experience counts, and the best way to get experience is just to find a job where you have responsibility early on. So that's my answer. I'm sticking to it.
So I want to thank Ann Bloom and CJRI. I want to thank CAPS. I want to thank the ACS. I want to thank BCLT for making this possible. We have this room for those who are able to stay around. David has generously offered to chat for the next number of minutes. If you are an LLM, come talk, and interested in consumer protection, come talk to me. Everyone, thank you. David, thank you so much for being here.